Welcome to our presentation on the role of trustees of living trusts. In the last session, I described what living trusts are and what they do. They avoid probate. They allow your successor trustee to step in without the expense of court intervention and manage your trust assets when you can't. Estate planning attorneys usually present living trusts at seminars enthusiastically because of these two benefits. However, in recent times, they've tempered their enthusiasm a bit. The main reason for that is the selection by their clients of successor trustees who lack either the character or competence or both to manage living trusts properly. Most people think of family members when it's time to name their successor trustee. This is natural and can be an excellent choice, but you should first ask yourself, what does a trustee have to do? And should I name one of my children as my successor trustee just because they are one of my children? There's an advantage to having someone who knows and loves you as the successor trustee of your living trust, but it's also a sobering experience to know what a successor trustee has to do. The successor trustee's first responsibility is as a fiduciary. Your fiduciary is a person with the legal responsibility of managing your assets for your benefit, not his or hers. Sounds clear enough, but it's possible for a successor trustee, especially an heir to your estate, to begin to see your assets as already belonging to them during your lifetime. This can lead to self-interested and blurry thinking. Of course, Mom wouldn't mind if I took an advance on my inheritance before she died, if only she could understand my financial problems. Successor trustees are held to high standards. Even though they should keep in mind the long-term interests of those you've named as beneficiaries of your trust, your interests come first. In fact, they must pay more attention to your trust's investments and disbursements than they do to their own. Dipping into those assets for their benefit while you are alive is not allowed, unless the trust gives them that power. Professional trustees know that. Family members may not. Your trustee also must read the trust carefully, both at the beginning and when questions arise. Again, this seems obvious, but many non-professional trustees think of the trust as a reference to be used in an emergency, if then. They never get round to studying the document. If they don't, they will not know when and how to distribute income and principal for your benefit, and what reports they need to make to the trust's long-term beneficiaries, your children, for example. Your successor trustee should also realize that they must invest your assets prudently. No putting your assets on red in Las Vegas. No investing everything you have on that sure thing a brother-in-law told them about. They have to know enough about your needs to determine how to balance investing for income and investing for growth, or at least find someone who can help them strike the proper balance. They have to keep track of investments and expenditures, and may have to report to future beneficiaries on the status of both. They need to make sure you pay your taxes. They need to locate legal or financial help to address issues that go beyond their expertise. They have to pay bills in a timely manner. Also, trustees are entitled to fees, though family members acting as successor trustees of living trusts often waive them. So is the successor trustee you have in mind up to handling those responsibilities? They don't have to be experts in all matters, but they have to have competence and character. If they lack either, no matter your affection for him or her, it may be better to name someone else. Some people complain about the slowness of successor trustees in distributing assets after someone's death. Sometimes delay is understandable. Real estate may have to be sold in a sluggish market. Personal property undesignated for specific heirs may have to be distributed fairly among contentious relatives. But sometimes the cause of the delay is a successor trustee without the time or expertise to handle unfamiliar transactions involved in estate management. There's no need to exaggerate the responsibilities of successor trustees. Simple, highly liquid estates have been distributed fairly and quickly even by first-time trustees who are honest, responsible, and competent. If a successor trustee has to deal with a complex trust, they can use an estate planning attorney or professional trustee to help them through the process. The cost will likely be much less than a probate proceeding, and the time between your death and the distribution of your assets will likely be much less as well. The qualities you look for in a successor trustee, you look for in the person that has your power of attorney for property management. Both roles can go on for years. Your successor trustee and the person to whom you grant power of attorney may be the same person, but there may be reasons, geographical proximity for example, for choosing different people for those roles. These choices are best discussed with an estate planning attorney. So one of the most attractive properties of a revocable living trust, it avoids court supervision, can also be its main weakness. It avoids court supervision. They are called trusts for a reason. Make sure that you fully trust the person you have in mind to act as your successor trustee or to exercise power of attorney for property management. Some attorneys discourage certain of their clients from having living trusts. Young people, for example, who are just starting out and may not have accumulated enough assets to make a living trust worthwhile. Sometimes attorneys will recommend that combining a will, which handles the distribution of their assets at death, with a power of attorney for property management, which handles the care of their assets in case of severe illness or accident, is a better fit for them. So don't feel bad if you don't have or don't want a revocable living trust. Again, let an experienced estate planning attorney be your guide. Most people who have a revocable living trust accompany it with what is called a pour-over will. This is a kind of mini-will meant to deal with assets you forget to put in your living trust that have no other way of passing to your heirs. Say you win the lottery or receive an unexpected inheritance, and before you die you simply forget to transfer your new wealth into your living trust. That's where the pour-over will comes in. It provides that upon your death, forgotten assets will be poured over into your living trust. If they are large enough, a probate may be needed to complete the transfer. Once those assets are in your living trust, your successor trustee can distribute them as your living trust directs. So, say you have a living trust and a durable power of attorney for property management. You've selected an outstanding successor trustee and granted power of attorney to an equally competent and trustworthy person. You have a pour-over will in place to take care of any loose ends upon your death. A living trust, a power of attorney for property management, and a pour-over will are the three pillars of a complete estate plan. What else do you need? Any experienced estate planning attorney will immediately answer an advance health care directive. That's what it's called in California anyway. Power of attorney for health care is another term. Living will is also used, though it can have a somewhat different meaning. Whatever we want to call it, we'll be talking about the importance of having an advance health care directive in our next session. I hope you take the time to learn about this fourth essential pillar of your estate plan. See you soon.